Hello students, we have to give some importance to doctrines and important section of Transfer of Property Act. As it is in some important doctrines and sections, we should go with this video. So let us continue. Please like, share, subscribe as per the first request is there. So this is the term immovable property is not defined under the Act TPA, but we are having this definition from General Clauses Act 1897. Immovable property shall include land, benefits arising out of land, and things attached to earth, or permanently fastened to anything attached to the earth. This is all defined in General Clauses Act. And according to Registration Act 1908, immovable property includes under the immovable property the benefits arise out of land. त्याच्यामध्ये बेनिफिट्स वरती जास्त इम्पॉर्टन्स आहे. हेरिडिटरी अलाउन्सेस, राईट ऑफ वे, लाईट्स, फेरीज अँड फिशरीज. सो अटॅच टू अर्थ means rooted in earth as in the case of trees or shrubs, embedded in the earth as in the case of walls or buildings. So we'll go for this is basic idea of immovable property. And who can transfer the property? Section 7 is important. Every competent person, every person who is competent to contract and having ownership can transfer property, or persons who are authorized to transfer property can transfer property validly. Although a minor is not competent to be a transferor, yet a transfer to a minor is valid. So this is very important. He can't transfer the property to some other person, but he can get. Yet transfer to a minor. This is important. Transfer to a minor is valid. We can transfer property to a minor. So this is section 7. Subject matter of transfer. Section 6. Property of any kind may be transferred. Property of any kind excludes from its purview the future property. A transfer of a future property can only operate as a contract which may be specifically performed when the property comes into existence. Property should be in existence for transfer. जे नाही आहे ती property तुम्ही transfer करू शकत नाही. The following has been held not to be immovable property. This is a list of not movable property. First, right of worship, government promissory notes, royalty, a right to recover maintenance allowance, copyright, a decree of sale on a mortgage deed, and decree of arrears of rent. Now we'll see which is recognized as immovable property. This is not immovable property, and this is immovable property. This is a list of immovable property. Right to collect rent of immovable property, a right to weigh, a right to collect dues from fair on a piece of land, the equity of redemption, the interest of mortgage, hereditary offices, right to collect land from trees, a right of ferry and right of fishery, right to receive future rents and profits of land reversion in property lease. These are list of recognized of immovable property. You can transfer all these benefits. These are benefits. Transfer for benefit of unborn person, section 13. What we saw here is section 6, 7 we just studied. Now section 13, where a transfer of property is interest created for the benefit of a person not in existence at the date of transfer, subject to a prior interest created by the same transfer. Very important. Subject to a prior interest created by a same transfer. The interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of transferor in the property. So these 3 points are important. Thus, if a property is given to an unborn person, two conditions must be specified. These are two conditions. Two conditions must be satisfied. It should be preceded by a life estate in favor of a living person. It should comprise the whole of remaining interest of the transferor so that there can be no further interest in favor of others. We'll go for doctrine of election. Section 35. Repeat it. Section 35 for doctrine of election. Election may be defined as the choosing between two rights where there is a clear intention that both were not intended to be enjoyed. Very important in this. The foundation of doctrine of election is that a person is taking benefit of an instrument must bear the burden. Must also bear the burden. The doctrine based on principle that a donee shall not be allowed to approbate and reprobate, that if he approbates, he shall do it all in his power to confirm the instrument which he approbates. So if you are getting a house, so doctrine of election says you have to pay the taxes also. So at the same time, when you are having person taking benefit from the instrument, he must bear the burden also. This is the example. When you transfer a house, the person will pay taxes. Exception to the doctrine of election. If the transferor gives two benefits to a person and one particular benefit is in lieu of an item of property belonging to that person, the transferor has asked to transfer to a third party. Then if the person elects to retain his property, he can retain the other benefit. So these are the exceptions. Section is 35, doctrine of election. We'll go to next slide. Transfer by ostensible owner or doctrine of holding out. Section is 41. Where a person is the ostensible owner of property and transfer the same for consideration with the consent of person interested in such immovable property, then the transfer shall not be voidable on the ground that the transferor was not authorized to make it. Voidable, not voidable on the grounds. This is important. Transferor was not authorized to make it, provided that the transferee has acted in a good faith. This word is important, good faith, and has reason to believe that the transferor had power to make the transfer. That the important in this is the transferor is the ostensible owner. The transfer is for consideration, and the transferee has acted in good faith, taking reasonable care to ascertain that the transferor had power to transfer. We'll go for next. Doctrine of feeding of grant by estoppel, section 43. So what we just studied is 41 and this is 43. Essential condition for application of doctrine of holding out, where a person fraudulently or erroneously represent that he is authorized to transfer certain immovable property and professes to transfer such property for consideration, such transfer shall, at the option of transferee, operate on any interest which the transferor may acquire in such property at any time during the contract of transfer subsist. This section shall not impair the right of transferees in good faith for consideration without notice of the existence of a said option. Doctrine of fraudulent transfer. इथं एररनस ट्रान्सफर होता. कशामध्ये? फीडिंग बाय द ग्रँट बाय एस्टॉपल मध्ये एररनसली और फ्रॉडुलंटली या दोन्ही इम्पॉर्टंट आहे. म्हणजे जी व्यक्ती ट्रान्सफर करत आहे ट्रान्सफरी, तिला असं खात्री आहे की आपल्याला ह्याचं राईट आहे ट्रान्सफर करायचा. And he professes to transfer such property for consideration. Consideration is some amount for the transfer. He gets some money and he is going to just having the belief that he is going to get the property and he is having the good faith that he has ownership and right to transfer. Doctrine of fraudulent transfer, where a person transfer his property so that his creditor shall not have anything out of property, and the transfer is called fraudulent transfer. सपोज एखादी केस किंवा कोणाचं देणं घेणं आहे एका प्रॉपर्टीवरती, किंवा हजबंड आणि वाईफचं समजा काही केस चालू आहे आणि त्याच्यामध्ये अदर पार्टीला काय मिळू नये म्हणून जी ट्रान्सफर केलेली असते प्रॉपर्टी, हा फ्रॉडुलंट ट्रान्सफर आहे. टू शो दॅट the person doesn't have any property, he transfers that property. So that is a fraudulent transfer. A debtor, in order to defeat or delay rights of creditor, this is also an example. Rights of creditor may transfer his property to some person who may be his relative or a friend. Such transfer will be voidable at the option of the creditor. The transfer is valid as long as the creditor does not challenge it in a court of law and gets a declaration that a transfer is invalid. So creditor, he has to file a complaint and challenge that in court of law. Otherwise, it is a valid transfer. Once the creditor sues the debtor and says that a debtor has the intention to deceive him, the transfer can be declared invalid by the court. So court will declare invalid. Until then, the transfer is valid. Mere preference of one creditor over the other is not a fraudulent under the section, even if the whole property is so transferred and nothing is left for the other creditors. So we'll continue this in the next video, and some important doctrines we will learn. So thank you very much. We'll continue in the next video. I'm continuing all the papers also. So paper 9 is also, I will post it today itself. With that, we need some doctrines also. So thank you.